You may be seated. Good morning, everyone. Thank you for joining us again. Did everyone heed my admonition not to discuss the case with anyone?
Yes.
Or let anyone discuss it with you?
Yes.
Or do any independent research while you're away from us?
Yes.
All right. Or watch any news accounts or read any news accounts of this case? All right. Thank you. I'm going to read to you some preliminary instructions that apply to this phase of the trial, and then we will hear from the attorneys. Members of the jury, you have found the defendant guilty of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for this crime is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you have heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient to impose the death penalty and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after arguments of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: 1, Demorris Ann Hunter was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crimes of attempted murder, voluntary manslaughter, and assault with a firearm are felonies involving the use or threat of violence to another person. 2, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Theresa Ann Green. Once the state has presented evidence of the existence of an aggravating factor, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate that the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, you will begin your deliberations. You should not form any definite or fixed opinions until you have heard all of the evidence, the arguments of the lawyers, and my instructions on the law. Until that time, you should not discuss the case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss this case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her that you're on the jury and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you if you need it. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you're at the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate about the case. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. These rules are imposed because jurors must decide this case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper to the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your valuable time as is necessary for a fair determination of this matter. And with that, I'm going to turn it over to the attorneys for their opening statements. Mr. Nunnally.
Please, the court. Counsel. Good morning. Ladies and gentlemen, this is the penalty phase that we spent the first week with y'all discussing. We got the cart before the horse now hopefully it will make a little bit more sense to you. Judge Munyon explained in her instructions to you what an aggravating factor is. It increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. That's really two categories of things, if you will, or facts that can fall within the reach of an aggravating factor. And in this case, we actually have one of each. We have the fact that the defendant has previously been convicted of multiple felonies involving the use of rubber violence or the capital felony, which I would suggest falls within the category of a factor that increases the gravity of the crime. We also have, in fact, Judge Munyon explained to you that the felonies at issue are in fact violent felonies. I'm going to come back to those. The second category that we have contained in the definition of an aggravating factor is the harm to the victim. You heard that testimony last week from Dr. Hutz, who described how the victim started. He described what the process of strangulation was. He described how long it takes to lose consciousness as you will be as an individual to be strangled. I would suggest to you, you will hear argument from this lady that I think is in the additional evidence to you don't need to follow any of this stuff. I would suggest to you that based on the evidence heard last week, you have evidence that is bringing possession over the pockets. When that man right there had his hands around her throat, squeezed the life out of her. That, ladies and gentlemen, is heinous, atrocious, or cruel. Another thing I would point out, you'll probably hear this again. The heinousness of aggravated is also sometimes abbreviated as HAC amongst lawyers that try these sorts of cases. Judge Bunyan gave you the definition of what a heinous murder is. She gave you the definition of what an atrocious murder is. And she gave you the definition of what a cruel murder is. Murder does not have to satisfy all three categories. Heinous, atrocious, or cruel. I would suggest to you, respectfully, that this murder actually is a police. I place to you confirmed as all the other issues last week. You will hear testimony today from, I expect, 3 witnesses. With respect to the prior conviction of another capital felony or a felony involving the use or threat of violence to another person, you will hear testimony from an assistant district attorney, almost called him an assistant state attorney, but they don't use that term in California. We have a gentleman here who was a prosecutor in Oakland, California, who's prosecuted Mr. Hunter. You will hear that in 1985, Mr. Hunter was convicted of attempted first-degree murder on 2 separate occasions, 2 separate events. One of those victims was shot in the face with a shotgun and survived. The other victim was shot 4 times and left paralyzed. The third victim involved in that series of events, Mr. Hunter threatened with a shotgun or firearm, but did not actually shoot. On another occasion, in 1985, Mr. Hunter committed voluntary manslaughter, killed a man named Caesar Goodline. Mr. Hunter served time for these offenses. He was released. 2002, Mr. Hunter shot Laura Hunter, relative of his then girlfriend, twice in the head, killed her. Then he fled. After he committed murder. Hunter has been convicted of all 5 of those felonies. I suggest to you that those 5 violent felonies are established beyond and to the exclusion of any reasonable doubt, and that they are entitled to your ultimate consideration to bring those later. Likewise, I submit to you that the heinous aggravator, the heinous atrocious or cruel aggravator, is also established beyond and to the exclusion of any reasonable doubt, and is entitled to very great weight. Your sentencing calculus, and Mr. Buston will speak more with you about that close of all of the evidence. Now, in addition to a prosecutor from California that you will hear from shortly, you will also hear from a fingerprint examiner with the Orlando Police Department, who has compared the fingerprints taken from Mr. Hunter at the time of his various California convictions to known fingerprints taken here in Orlando of Mr. Hunter. He will explain to you why this is one of the same person. California prosecutor, done by John Brohard, will explain to you in detail how the California process works through different hours. In some ways, and he will explain all of those things to you. The other thing that you will hear from us this morning is a victim impact statement. That victim impact statement is prepared by pages case we heard from last week is that it will be read to you by a member of our office, replacing the page record. Victim impact, as you have heard repeatedly, is not evidence, but it is to be considered in explaining the loss to the community and to her family by Mr. Hunter's murder of Theresa Ann Green. I expect that the defense will present various family members to testify to you about Mr. Hunter's loss. I don't know exactly what they're going to say necessarily. However, I would suggest to you that you should consider all this mitigation. I suggest to you, in the day, mitigation will hear from others and their friends are entitled. It is absolutely part of considering the weighing process, details and how you are to arrive at your sentencing recommendation. It is not simply an accounting process, it is a weighing process. I would suggest to you that at the end of the day, ladies and gentlemen, the aggravating factors of Mr. Hunter's multiple prior convictions for violent or capital felonies and the heinous, atrocious, or cruel nature of the murder of Theresa Ann Green leads to the conclusion that a recommendation for sentence of death with Demorris Hunter be your ultimate recommendation.
Would the defense like to make an opening statement at this time?
Your Honor, we'd like to reserve for after this case.
All right, thank you. State, you may call your first witness.
State calls John Brohard.
I do.
Does everyone have a pen? Thank you. Sir, could you state your name and spell your last name for the court reporter, please?
My name is John Brohard. Last name is spelled Brouhard.
Thank you. Mr. Buckley, you may inquire.
Thank you, Your Honor.
Morning, sir.
Good morning. Thank you.
What do you do for a living?
I work as an assistant district attorney in Alameda County, California, which is where Oakland, California is located.
What do you do on a day-to-day basis now?
So I'm a criminal prosecutor, and my current assignment is I supervise our felony trial staff attorneys.
Can you describe for the jury your education and background that allowed you to become first an assistant district attorney?
Yes, I got a undergraduate degree from the University of Southern California, and then I graduated from law school at the University of California at Berkeley, and then began my career working as a lawyer.
Can you describe for the jury the different positions you've held as a lawyer and what you've done during your career?
So after law school, I spent a year as a law clerk to a federal judge in San Francisco. After that, I worked at a law firm for 2 years. And then after that, I was hired by the Alameda County District Attorney's Office, and I've remained at that office ever since.
What kind of positions have you held at the district attorney's office?
So at the District Attorney's Office, we start off trying lower level cases, misdemeanor cases. I did that for a number of years. Then we started handling felony cases, and we initially put on what are called preliminary hearings, like mini trials on felony cases. And then eventually I started trying felony cases. And over the years, I've been on felony trial staff for the bulk of my career, trying felony cases. And while I was doing that, I also became the supervisor of our gang unit. So prosecuting primarily criminal street gang related crimes. For a period of time, I worked as a charging deputy, which means we review police reports and make decisions about whether we're going to file criminal charges and what charges. And then I moved into my current assignment where I now supervise the people that are actually doing the jury trials.
During the course of your career, have you tried homicide cases?
I have.
Have you tried death penalty cases?
I have.
All right. How long have you been a practicing lawyer?
34 years, I'd say.
How long have you been a practicing district attorney?
About 31 years.
Based on your experience as a district attorney in California, are you familiar with the various documents associated with a defendant's arrest?
Yes.
Are you familiar with the process that occurs when someone is arrested and booked into a jail in California?
Yes.
How are you familiar with those types of documents?
Those documents are documents that we use almost daily in the job of being a prosecutor. So we're reviewing records relating to arrests, reviewing court documents, records from the law enforcement agencies. So it's just part of the daily work of being a prosecutor.
Are you also familiar with documents related to when a defendant is sentenced after being convicted of a crime, either from the county jail or from the Department of Corrections?
Yes.
Are you familiar the same way you just described?
Yes, we have, as part of our job as a prosecutor, we are oftentimes in court dealing with proving up prior convictions, and I'm familiar with the kinds of records we use to establish that.
This time, Your Honor, the state would introduce a certified copy of court records and for the defendant's conviction in 1985 case with docket number 83356 as State's Exhibit 41.
Any objection? It will be received as State's Exhibit 41.
State would also introduce certified copies of court records and conviction for the defendant's conviction in 1985 California case with docket number 83355 as State's 42. It's State's Exhibit AP for identification.
Any objection? It will be received as State's Exhibit 42.
This time, State would introduce State's Exhibit AQ, which is Department of Corrections records from the defendant's 1985 convictions. Included with it is a business record certification and proper notice has been given. The state would move to introduce that as State's 43.
Any objection? It will be received as State's Exhibit 43.
State would move State's 8R for identification into evidence, which is a booking photo and fingerprints of the defendant's 2003 arrest, along with a business record certification and proper notice has been given.
Any objection?
That would be State's 44, Your Honor.
It will be admitted as State's Exhibit 44.
And finally, the state would move to introduce certified copies of court records for the defendant's conviction in that same 2003 arrest under docket number 146022.
Any objection? It will be received as State's Exhibit 45.
Are you familiar with a man named Demorris Andy Hunter?
I am.
How?
I prosecuted him for murder, a murder that occurred in 2002 and was prosecuted in Alameda County. And had a jury trial, I believe, in 2005.
We're going to get into a little more of those specifics in a little bit. I know it's been many years since then, but do you happen to see him in court here today?
I do.
Please point him out and tell me what he's wearing and where he's sitting.
He's sitting at the table over there, wearing a gray colored shirt.
Your Honor, may the record reflect the witnesses identified the defendant?
The record will so reflect.
During the course of preparing for that trial that you had for a 2002 murder in California, did you also investigate and review documents associated with his prior criminal history?
I did.
Without telling me the results right now, how did you go about doing that and getting those records?
So as part of the case that I prosecuted, we obtained records regarding the defendant's prior convictions that were also in Alameda County, the same county I work in. And so we obtain certified copies of court records, documents that are in the court file. We obtain records from the Sheriff's Department that relate to arrest and fingerprinting, identification, that sort of thing. And we also obtain records from the California Department of Corrections, which is the prison system in California, that also have records that document convictions for persons.
Did those records that you obtained from those various agencies all relate to crimes and convictions that had happened in 1985 that the defendant was convicted of?
Yes.
I want to ask you some general questions about what happens when someone gets arrested in California. When a person is arrested in California by law enforcement, what happens to that person when they're brought to the county jail?
So the arrests are done, the documentation is done at the county level. So in Alameda County, if a person is arrested in Alameda County by any police agency, then they are booked into the county jail. And in that booking process, there's a number of things that occur, one of which is taking fingerprints of the person who's arrested, obtaining identifying information about that person, name, date of birth, that sort of thing. Also, a photograph is taken of the person upon their arrest to document and identify the person who's arrested.
Are those records you just described normally kept by certain agencies, such as the Alameda County Court or the California Department of Justice?
So the records regarding the arrest are kept by the Alameda County Sheriff's Department, and then further records are maintained by the Superior Court of Alameda County, and then records are maintained by the Department of Corrections, the prison system as well.
And on a later date, can someone like yourself, through the process you just described, go get those records to use in, like, your case?
Yes.
All right. Also, when someone is arrested, are they assigned a specific number?
Yes, in Alameda County, when somebody is arrested, the first time that they're arrested in Alameda County, when they're identified, the fingerprints are taken, they are assigned a unique, I'll call it a number. We call it, it's a personal file number. The shorthand for that is PFN. And that identifier begins with 3 letters and then has 3 digits. And it's unique to that individual.
Does that number then track to that unique individual any future time that person could be arrested?
Yes, so if after the initial arrest, when that person is assigned a PFN, then let's say sometime later they are arrested again, when they are fingerprinted at the jail, then they link that person and they maintain that same PFN number for the rest of their life.
Does that unique PFN number appear on many of the documents that we're going to look at to track the defendant as being the same person arrested for all these different crimes?
It does.
After the defendant is arrested for a crime, how does that defendant officially get charged with the crime and enter into the actual court system?
So if somebody is arrested, then the arresting agency, like the police department, in this case, the Oakland Police Department, provides police reports and materials to the district attorney's office, which is the prosecutor's office. And we review those materials and we make decisions about whether to charge somebody with a crime, and if so, what crimes we're going to charge. If we decide to charge a case, then we file the charges for felonies in California. That filing begins with filing what we call a complaint, and it lists the defendant and it lists the charges. Then that gets filed with the court and begins the process of a criminal case against that defendant.
What happens when a person either enters a plea admitting what they did, admitting their crime, or goes to trial and is convicted by a jury? What kind of documents are generated in that process?
So in some cases, a person will be convicted as a result of entering a plea of guilty. And so in that process, there is a hearing in front of a judge where certain things take place, and the defendant enters the pleas of guilty. There are various court documents that essentially document that. There's a transcript that's prepared of the court proceedings. There are documents, we call them minutes or minute orders, that the clerk prepares that are all filed with the court to document the fact of conviction. After somebody's convicted of a felony, the other way that can occur is we can have a trial, and if there is a jury verdict of a conviction, then those documents are recorded in the court file as well. And after conviction, then eventually there will be a sentencing that a judge does, and that sentencing is also documented by a transcript and by various documents that are what we call abstracts of judgment. That's kind of the primary document that shows what the person was convicted of and what they were sentenced to.
Do prosecutors and defense lawyers and judges and everybody in the system rely on these records to do their job?
Yes.
If a person is sentenced to prison, do the prisons in California also maintain certain records regarding that now convicted inmate?
Yes, so if somebody is sentenced to prison, then when they are brought to the prison system, they're booked into the prison system, similar to when they're booked into the county jail. So they obtain fingerprints, photograph, identifying information, and they also receive from the court the documents, the abstract of judgment, the documents that show the prison, okay, this is what this person was convicted of, this is what their sentence is, so that they can input that information for their system as well.
Does the Department of Corrections or the prison system also often collect fingerprints and take photographs of the now convicted defendant?
They do.
And have you had an occasion as a prosecutor to use and refer to all of these different types of records that you've talked about today?
Yes, all the time.
I'm going to ask you some specific questions about the records that were just introduced into evidence dealing with the defendant, and have you explain kind of what they mean. Start with an exhibit of States 41. What is this document?
So this is the first page of a criminal complaint that was filed against this defendant relating to the 1985 cases.
And who is the victim of what we see on the screen now?
So there are, in the 1985, there were 2 cases, but they were dealt with together and sentenced together. So this is one of the cases, and this is a charge that relates to the victim, whose name is Adolphus Williams.
What were the charges associated with Adolphus Williams that the defendant was charged with?
Attempted murder and use of a firearm and assault with a firearm, also with use of a firearm.
Is there a specification of what kind of firearm was used?
In that case, it was a sawed-off shotgun.
And what legal effect does this complaint have in the system and the defendant?
So this document, when it's filed, is the initiation of a criminal case against this defendant. And so the document is prepared by the district attorney's office. It is signed by a deputy district attorney, and it's also signed by a police officer. Once that's done, then that gets filed with the court and begins the case.
And what date is alleged that these crimes were committed regarding Adolphus Williams?
February 4th, 1985.
I'll show you that same page now with a portion blown up. You mentioned earlier a PFN number. What do we see in this slide?
So on the complaint, oftentimes the PFN number for the defendant appears. So for this defendant, his PFN number was AOW126, and that's printed on the complaint.
And will that unique PFN number appear in some of the future documents we're going to look at?
Yes.
So what do we see on the second page of this exhibit?
So this second page is the complaint from the other case that was filed. These two cases were filed at different times, close in time. But this is the complaint for the second case in 1985.
And what's the victim's name of this second case in 85?
This is Eric Wright.
What charges was the defendant charged with regarding Eric Wright?
Attempted murder with use of a firearm and the infliction of great bodily injury.
Showing you now Exhibit 42. What do we see here?
This is an amended complaint relating to one of the earlier cases that we talked about before.
We see up at the top, it says first amended.
Yes.
What is it meant by an amended complaint? Why would that happen?
So once we file charges, sometimes we will change things, add charges, sometimes reduce charges. So you can file an amended complaint that has different charges or additional charges from the original complaint.
So does this image we see of regarding states 42, is this also again still dealing with Eric Wright and the charges against Eric, or charges involving Eric Wright as a victim against the defendant?
That's correct.
Okay. Showing you page 2 of that amended complaint. What does this show?
So this shows the amended complaint, and it has the charges related to Eric Wright. And then there are it shows a second count regarding Eric Wright as well for assault with a firearm and infliction of great bodily injury.
And showing you now the third page of that amended complaint. What do we see here?
An additional charge, which is labeled as the third count, and it charges the defendant with murder of Mr. Cesar Guzman.
Now, did the defendant eventually enter a plea with a charge of voluntary manslaughter against Cesar, with Cesar Guzman being the victim?
Yes.
And what was the date of the offense of the crime committed against Cesar Guzman?
January 6th, 1985.
Showing you a page from State's Exhibit 41. Did Demorris Hunter enter a plea in connection with the various crimes that we just talked about in those cases involving the victims, Adolphus Williams, Eric Wright, and Cesar Guzman?
Yes.
What does this document show?
So this is a court document that documents the sentencing for those charges that the defendant pled guilty to on those two cases.
Showing you the same document again with something blown up. Do we see that same unique personal file number present on this document as well?
Yes, that same PFN appears on many of the court records as well.
And what is the significance again of that PFN number?
The PFN number is a unique identifying number for this defendant. So it's used on various documents to essentially establish the identification of the person who was charged or convicted in this case.
And showing you that same report and sentence from State's Exhibit 41. According to this document, which pertains to the crimes committed against victims Adolphus Williams, let me back up. According to this document regarding the victim Adolphus Williams, what was the defendant convicted of?
Attempted murder and personal infliction of great bodily injury.
What does that mean?
So attempted murder is an attempt to kill somebody. And then in California, there is a charge, that can be what we call an enhancement, where somebody, if somebody personally inflicts great bodily injury during the commission of the crime, that can be an enhancement.
In California, what is meant by the term attempted first-degree murder?
Attempted first-degree murder in California is, what it means is that the defendant attempted to kill another human being with what we call express malice aforethought, which is a fancy way of saying that at the time they committed the crime, they had in their mind an actual intent to kill that human being.
Like premeditation?
Correct.
And according to this document, did the defendant admit to inflicting great bodily injury on Adolphus Williams as part of this plea agreement?
He did.
And what does great bodily injury involve in California?
It is serious, not trivial injury. So it has to be greater than a minor injury.
Would being shot in the face with a sawed-off shotgun constitute great bodily injury?
Yes.
And when did this conviction for the crime involving victim Adolphus Williams occur?
The conviction occurs when the defendant, in this case, when he changed his plea to plead guilty, and that occurred on November 20th of 1985.
Showing you a document in States 42. What does this document show?
This is the same document as before. It's documenting the sentencing hearing for the other case where the defendant was sentenced together.
The one involving Eric Wright and Cesar Guzman?
Yes.
And showing you again that same document with a blow-up portion. Do we see that same PFN number linking this document to this defendant?
That's correct.
Okay. And the report here that we see as far as the other case shows, it says see attachment. Was there an attachment?
Yes.
Showing you the next page of States 42, the attachment. What does this show?
This now documents the crimes that he was convicted of and that he was sentenced on.
Did you also review the transcripts of the hearing in which Demorris Hunter entered a plea in this case?
I did.
Based on the change of plea transcript, was the crime that we saw regarding assault with a firearm involving Eric Wright dropped?
Yes.
according to the change of plea transcript, was a charge of assault with a firearm added for a victim named Jorge Hernandez, who was with Cesar Guzman at the time he was killed.
It was.
So according to this document and the other document, the change of plea transcripts you reviewed, which pertains to crimes committed against Eric Wright, Cesar Guzman, and Jorge Hernandez, what crimes was Demorris convicted of in this case?
So he was convicted of attempted murder of Eric Wright. He was convicted of voluntary manslaughter for Mr. Guzman. And he was convicted of assault with a firearm on Mr. Hernandez.
What does the crime of assault with a firearm involve in California?
Assault with a firearm is a fancy way of saying that you shot at somebody. You can also be committed where you point a loaded gun at somebody, but something happens where you don't fire. So pointing a loading gun at somebody can be assault with a firearm, but it's more commonly the shooting of a gun at a person.
And now, just so the jury isn't misled, in this specific case involving Jorge Hernandez, he was not alleged to have fired at Jorge Hernandez, just pointed a gun at him, correct?
That is correct.
So he was convicted of assault with a firearm on Jorge Hernandez, and you mentioned voluntary manslaughter involving victim Cesar Guzman.
Correct.
What does voluntary manslaughter mean in California?
Voluntary manslaughter is what we call a lesser included offense to that of murder. So if somebody kills somebody unlawfully, normally that is murder, but it can be reduced to voluntary manslaughter. The most traditional way that happens is, for example, if the killing was deemed to be done in the heat of passion, it makes it less than murder. So he pled guilty to a lesser crime of murder, which is voluntary manslaughter, which is the unlawful killing of human being without malice aforethought.
And did that involve a firearm?
Yes,
Did he admit during the sentencing documents that the defendant used a firearm when he killed Cesar Guzman?
yes, he admitted an enhancement that he personally used a firearm during the commission of the crime.
Did he also admit to personally using the firearm to point at Jorge Hernandez for the aggravated assault conviction?
Yes,
Did he also admit to inflicting serious bodily injury upon Eric Wright by shooting him?
yes.
Showing you next page of States 42. What is this document that we see?
So this is the abstract of judgment. This is a record that is prepared by the court and that is filed with the court. And this is what documents sort of at the end, the charges the person was convicted of and the sentencing.
And do these documents also have that same PFN number you've been describing?
Yes,
And we see up top a circle around, and it's not real easy to see here, but a circle around one of the docket numbers, 83355. What does that signify?
so there were two dockets, two cases that were put together for sentencing. And both of those dockets are listed on this abstract of judgment. So the abstract of judgment puts it all together.
So this abstract contains the results of all of the different charges and crimes that we've been talking about so far.
Correct.
And we see some X's in the middle of this document. What do those mean?
Oh, those are, they put an X in the box to indicate for a certain crime. For example, if there was an enhancement like use of a firearm or infliction of great bodily injury.
And referring to this next page, what do we see here?
So this is still part of that abstract of judgment. And it shows the conviction for attempted murder on one of the counts.
As a result of the defendant's convictions for voluntary manslaughter on victim Cesar Guzman, attempted murder on victim Eric Wright, attempted murder of Adolphus Williams, and assault with a firearm of Jorge Hernandez, was he sent to the Department of Corrections to serve a prison sentence?
Yes.
Once an inmate arrives at the Department of Corrections, are they assigned a Department of Corrections or a California Department of Corrections number?
Yes.
Does that person have that same unique number if the person goes back to prison?
That depends. The Department of Corrections assigns a unique number the first time that person goes to prison. A person can be released from prison on parole. If they commit a new violation while they're still on parole and are sent back to prison, they will keep that unique Department of Corrections number. On the other hand, if they complete parole and it's not until later that they commit a new crime that they're sent to prison to, then the Department of Corrections will give them a new Department of Corrections number.
So the document we see here, which is in States 43, what is this?
So what this is a certification and cover page from the Department of Corrections. That is, bottom line is, we can order records from the Department of Corrections, and we do that all the time. And there's a process for this. And then when the Department of Corrections sends us the records, they come with this cover page and certification, and then the records are attached to that.
There's a certification, just verify the accuracy of the records.
Correct.
Okay. And what was the Department of Corrections number assigned to Demorris Hunter as a result of these convictions we've been talking about?
It's the letter D like David, 23120.
Does the Department of Corrections also maintain some of the sentencing documents that we've looked at already as well?
Yes,
Do they also fingerprint when the person arrives at the Department of Corrections?
they do.
What do we see here on the next page of States 43?
So this is a copy of the fingerprint page from the Department of Corrections from when they took fingerprints when the defendant was received.
Whose name appears on the fingerprint card?
The defendant, Demorris Hunter.
And is there a DC number at the top of, a Department of Corrections number at the top of that?
Yes, it's kind of faded.
Can you make it out? If not, it's okay.
23120. Looks like D like David.
Okay. Does that appear to be the same number that was present in the letter we just looked at?
Yes,
Okay. Does the Department of Corrections also photograph an inmate?
they do.
Showing you next page of States 43. What does this show?
This is the Department of Corrections photograph of the defendant that they had on file with their records.
You recognize the person in the photograph?
I do.
Who is it?
The defendant, Demorris Hunter.
Is the DC number on this photograph also the same number that we saw in the fingerprint card and in the letter from Department of Corrections?
It does.
So moving on, you mentioned earlier that you actually were the prosecutor that prosecuted the defendant for the murder of Ivona Huntley.
Correct.
How did you become the prosecutor assigned to that case?
At that time, I was working on trial staff and I was prosecuting murder cases. And so I was assigned this case to be the prosecutor for a jury trial.
And when did that murder actually occur?
The murder was in 2002.
Following that murder, obviously, did law enforcement do an investigation?
Correct.
Was the defendant eventually arrested?
He was arrested
Where?
in Houston, Texas.
Was he then brought from Houston, Texas, back to California to answer for your charges?
Yes.
And after he answered for your charges and your jury trial was over, was he eventually then brought to Florida to answer for these charges?
Yes.
When he was brought back to California from Houston, Texas, would he have been booked into the Alameda County Jail?
Yes.
Would he have been photographed and fingerprinted?
Yes.
Is that standard procedure when someone is booked?
Yes.
Showing you photograph 40, or photograph from states 44. What do we see here?
So this is a certified copy of the booking record for the defendant when he was booked after his arrest in Texas and brought to California.
And when was he actually brought to the Alameda County Jail?
He was booked on March 6th of 2003.
Do you recognize the person in the photo?
I do.
Who is it?
It's the defendant, Demorris Hunter.
What was the date of birth associated with Demorris Hunter according to the booking information?
April 18th, 1966.
We also see a PFN number listed here. What number is that?
So we see that same PFN number, the AOW 126. In this record, it has some digits in front of it, which is 010. That is, for lack of a better word, a computer code for where he was booked.
Okay. Is this the same unique PFN number that we saw on all the documents that we looked at regarding the 1985 conviction?
Yes,
And does that further show that we're talking about the same person?
it does.
Showing you the next page of States 44. What is this?
This is a certified copy of the fingerprint records that were taken by the Alameda County Sheriff's Department when the defendant was booked into our jail in 2003.
In the top right, do we see that same unique PFN number?
We do.
And what's the date of birth associated with the fingerprints?
It is 4/18/1966.
What's the name associated? Well, what is the name we see on this fingerprint card?
Demorris Hunter.
Okay. Now, is the middle name misspelled on this one?
Maybe, it's hard to read this close up, but I think there was a misspelling of the middle name.
A-N-O-Y instead of A-N-D-Y.
Yeah, Noy, yeah,
Does all of the other information on this match the defendant?
it does.
Likely a typo.
Yes.
After Demorris Hunter was booked into the Alameda County Jail in 2003, having been brought there from Houston, Texas, did the criminal case against him for the murder of Ivona Huntley in essence begin?
Yes,
Was he charged with the murder of Ivona Huntley in a formal charging document?
he was.
Showing you the first page of States 45. What does this show?
So this is a charging document that is called an information. So when a person is charged with a felony, the first charging document that is filed is called a complaint. And then there can be a preliminary hearing that's conducted. And after that preliminary hearing, if the defendant is what we call bound over for trial, then we file charges in an information. So the information is the charging document that is in effect at the time of trial.
And is this the charging document that brought him into the justice system to be prosecuted for the first-degree murder of Ivona Huntley?
This would have been, there would have been a complaint first, and then after the preliminary hearing was when this was, the information was filed.
See. When did the murder of Ivona Huntley actually occur?
March 29th, 2002.
What was he charged with regarding the murder of Ivona Huntley?
He was charged with murder, and he was charged with personal use of a firearm causing death.
Would he have been charged with the crime that we know here as first-degree premeditated murder?
So in California, we charge the crime of murder, and then the degree of murder is determined by the jury.
Okay. Eventually, was he convicted of the crime of first-degree murder?
He was.
Does that involve premeditation, like here?
Yes, it is. First-degree murder in California means that the murder was willful, deliberate, and premeditated.
In California, can a person's prior convictions be used to enhance the penalty associated with this murder charge?
Yes.
Do you typically allege those prior convictions in the charging document that we look at here?
Yes.
I'm showing you, excuse me, page 3, I believe, of States 45. What do we see here?
So in the information, after we list the actual charges, then we allege or charge him with having prior felony convictions. And they are listed out and labeled. For example, first prior conviction is at the top, then there's a second prior conviction, and so forth.
And did you include the prior convictions involving the crimes committed against Adolphus Williams, Cesar Guzman, Eric Wright, and Jorge Hernandez in your charging document?
Yes.
Do we see that in these various portions of your charging document?
Correct.
Did Demorris Hunter go to trial in Alameda County regarding the murder of Avona Huntley?
Yes,
You were the prosecutor that tried the case?
I was.
What was the result of that trial?
He was convicted by the jury of first-degree murder, and the jury found true that he personally and intentionally discharged a firearm causing death.
And what do we see in this page of States 45?
So he was eventually sentenced after that trial. And so this is the abstract of judgment, like we saw before for the 1985 cases. This is the abstract of judgment for the case that I prosecuted that documents what he was convicted of and what his sentence was.
And he was convicted according to the document of first-degree murder?
That's correct.
And does your name also appear on the sheet?
Yes, they list my name as the counsel for the people, which is the prosecutor.
So to wrap this up, was the defendant convicted of attempted first-degree murder causing great bodily injury in 1985 for victim Adolphus Williams for shooting Mr. Williams?
Yes,
Was he convicted of voluntary manslaughter in 1985 on victim Cesar Guzman while using a firearm for shooting and killing Mr. Guzman?
yes,
Was he convicted of attempted first-degree murder in 1985 for victim Eric Wright, causing great bodily injury as well for shooting him?
yes,
Was he also convicted of assault with a firearm for pointing a gun at Jorge Hernandez?
yes,
And was he ultimately convicted of first-degree murder in 2005 for victim Avona Huntley for shooting and killing her from a premeditated design?
yes.
Thank you, sir. No other questions, Your Honor.
Cross-examination.
No questions, Your Honor.
Any questions from the jury? May this witness be excused.
Yes, Your Honor.
You are free to go, sir. Thank you.
Thank you, Your Honor.
State, you may call your next witness.
State calls Adria Garotti.
Raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, could you state your name and spell your last name for the court reporter, please?
Yes, my name is Adria Garotti. That is spelled A-D-R-I-A. And my last name is Garotti, spelled G-H-A-R-A-T-I.
Good morning, ma'am.
Good morning.
Where do you work and what do you do?
So I currently work for the City of Orlando Police Department, specifically in the latent print unit. And my official title is Senior Latent Print Examiner.
Where do you work? Where's your headquarters?
Our headquarters is in downtown Orlando, and I work on a remote site. I don't work at the headquarter building.
And what do you do on a day-to-day basis as a latent print examiner?
As a latent print examiner, we accept evidence that's been submitted to the unit for the possible presence of latent prints. If latent prints are processed or developed, we will then compare those prints to any known record prints that have been submitted. If there are no known records, we enter those into a specialized database. It's a repository of known records that is maintained by the state or FDLE. We generate notes and reports to our findings. We testify in court when needed.
Can you describe for the jury your educational background and your training that allows you to do that job?
Sure. I received a bachelor's of science and a certificate in criminalistics from the University of North Texas in Denton, Texas. During my senior year in college, I did a one-year internship, and that was at the Tarrant County Medical Examiner's Office in Fort Worth, Texas, where I trained underneath a qualified latent print examiner, assisting with the identification of unidentified human remains, as well as processing evidence in the laboratory for fingerprints. Upon graduation, I was accepted to the Virginia Institute of Forensic Science and Medicine. That was a fellowship program in latent prints, where I worked underneath qualified latent print examiners at the Virginia Department of Forensic Science. It was a one-year intensive training program. And after graduating that program, I was then hired by the Virginia Department of Forensic Science, where I worked in that state laboratory for several years.
How long have you been a latent print examiner?
I've been a latent print examiner for approximately 21 years now. I've worked for various different agencies throughout the U.S.
Have you been permitted in court to give opinion testimony regarding latent fingerprint analysis?
Yes, I have been accepted as an expert witness in court in multiple states, as well as federal court, over 24 times probably.
The jury has already heard a lot about fingerprints, what latent fingerprints are, what known prints are, so I'm not going to go into that all again.
Okay.
But how do you go about doing a fingerprint comparison? What method do you follow?
Okay. So what is generally accepted in the field of latent prints, the methodology that we use is commonly referred to as ACE-V. It's an acronym. It stands for Analysis, Comparison, Evaluation, followed by a -V for verification. And as the primary latent print examiner, you'll do the first 3 steps, the analysis, comparison, and evaluation.
What does the analysis and comparison and evaluation involve?
Okay. So the analysis step is the first step. And what we're doing is we're just looking at the overall print to determine if there is friction ridge detail present. So the palms of the hands and the feet are all covered with that specialized skin that you may be aware of called friction ridge skin. And what we're looking for is the presence of that skin. We're looking for the anatomical feature. So is it a finger? Is it a palm? Is it a joint? Is it a foot? And then we're going to go a little bit further and determine, is it up? Is it down? What is the orientation? So this is a basic overall view of that print. And then we're also going to determine if there's enough information for us to move on to our comparison phase.
And if there is, what's the comparison phase?
So if we do move on to the comparison phase, if we determine that there's a sufficient amount of ridge detail present, as well as some discriminating characteristics within that print, we'll move on to that comparison phase. If not, we'll stop the exam there, and we'll determine that the print is not of value. And if we do determine it's not a value, we don't compare any. If we do decide it is a value for comparison, we will then do a side-by-side analysis of any known record prints that have been submitted. And we're going to look for 3 different levels of detail that we have. So the first level is going to be your basic pattern types. And if the examiner prior went over those are arches, loops, and whorls. We're looking for the presence of those patterns if they exist in the latent print and the known. And then we're going to go through our second level of detail where we look a little bit further into the print. And that's where we're looking for what we call discriminating characteristics. Those characteristics are commonly referred to as a ridge ending, which is a ridge that flows through the pattern and comes to an abrupt stop. We have bifurcations. That's a ridge that flows through the pattern and splits into 2 separate ridges. And then we have a short ridge that is a ridge that is as long as it is wide. So we're looking for the presence of those characteristics as well as how discriminating are they in that print specifically. Every individual has a combination of those patterns and those ridge characteristics, but to date, no two people have been found to have the exact same fingerprints or palm prints.
And what's the E stand for again?
So the E stands for evaluation. Once we've completed the comparison phase, doing that side-by-side comparison, we will then come to a determination. At the City of Orlando Police Department, we have 3 different conclusions that we come to. We'll do identification is the first one, meaning that all of the ridge detail present, there was a sufficient amount of that, quality and quantity of that ridge detail and those characteristics to determine that those fingerprints came from the same source that we're comparing. We have exclusion, meaning that there was a sufficient amount of quality and quantity of ridge detail and characteristics present that were in disagreement to determine that they did not originate from the same source. And then we have what we call inconclusive. And inconclusive typically means that we don't have enough information to make that determination. For example, we may have a situation where we only had fingerprints taken and we're looking at a palm print. So we may have to request additional information or that subject's palm prints be taken so we can complete a conclusive comparison.
Thank you. This time, Your Honor, I request permission to allow this witness to give opinion testimony in the area of fingerprint analysis and comparison.
Any voir dire?
No, ma'am.
She will be permitted to render her opinion in that area.
May I approach, Your Honor?
You may.
Showing you what's been introduced into evidence in State's Exhibit 35. Can you take a look at that and tell me if you recognize that document? These are represented to be known fingerprints taken from the defendant, Demorris Hunter.
Do you want me to open it or just, okay. I do recognize that.
Did you examine that document as part of your fingerprint analysis that you did in this case?
The document has a fingerprint card and then a set of palm print cards. I did examine the fingerprint card for my comparison, yes.
May I approach?
May.
Showing you what's been introduced into evidence in State's Exhibit 44. Were you also provided fingerprints from an arrest of defendant Demorris Andy Hunter in California in 2003?
Yes, this is the fingerprint record that I received. It was a certified copy of the fingerprints from Alameda County, California, which is in Oakland, California, I believe. And it has bearing the name Demorris, spelled Demorris, middle name Anoy, Anoy, and last name Hunter, common spelling Hunter.
Did you compare the known fingerprints taken from the defendant Demorris Hunter to the fingerprints contained in that arrest fingerprint document in 2003 from Alameda, California?
I did compare the fingerprint record and the state exhibit to this fingerprint card bearing this name, yes.
What were your results?
I was able to determine that both cards were made by one and the same person. Yes.
No further questions, Your Honor.
Thank you, ma'am.
Cross-examination.
No questions, Your Honor.
May this witness be excused.
Yes, Your Honor.
You are free to go, ma'am. Thank you.
Thank you.
State, may call your next witness.
The next witness will be Brittany Adkins, who was a victim advocate from the State Attorney's Office reading the victim impact statement for Octavius Hayes.
All right, thank you. Please come forward.
Before she begins reading, may we approach briefly, Your Honor?
You may. Mr. Nunley?
All right, guys, I'm sorry. It's been a very,
Good morning, ma'am.
Morning.
but
If
yes,
you would, tell us your name, please, and spell your last name for the court report.
time,
Brittany
but
Atkins, A-D as in Delta, A-I-N-S.
real quick, they did a jury pool of about 150 to at most 175 people last week on Thursday and Friday. And then they were supposed to have all these conversations with them and then narrow it down so they can start to do like the individual juror voir dires and things of that nature starting today for Isaiah Chance, Sean Gathright, and then Rashad and Davion Murphy. But it is set to take a little bit longer because since all of them are facing the needler at the same time, they also have to make sure the jury is good for that because it could end up in what we're in now in Florida, another penalty phase. So they are expected to possibly start presenting evidence for the Julio Fulio Part 2 around April 22nd or 23rd. So we may not hear anything this week, but they did start today. And good morning, good morning.
And ma'am, how are you employed?
I work for the State Attorney's Office of the Fifth Circuit.
In the course of your duties with the State Attorney's Office, did you have the occasion to obtain a written victim impact statement from a person known to you as Octavius Hayes?
I did.
And have you reviewed that statement?
I have.
Ms. Atkins, let me get you to point that microphone a little bit more. A little bit softer.
Sure.
Oh, there you go. And if you would, please, ma'am, would you read the statement provided to you by Mr. Hayes? from the
I will.
jury?
At only 13 years old, I was robbed of my mother's presence, her support, and her irreplaceable love. While other children were leaning on their mothers for guidance, I was forced to navigate the most formative years of my life in the shadow of her absence. Every milestone I have reached since then has been bittersweet, marked by the hollow space where she should have been standing. For over 20 years, my celebrations of birthdays, holidays, and special occasions have taken place at a gravesite. The most heartbreaking reality is that this is the only relationship my children will ever have with their grandmother. Their bond with her is limited to cleaning a headstone and choosing flowers for a memorial vase. They are growing up knowing her only as a name on a stone, deprived of the living warmth and wisdom that she would have poured into their lives. I have learned to live with this unimaginable pain, but I have not been allowed to heal. For over 2 decades, I have been subjected to the constant traumatic stress of continual legal proceedings. These years have served as a constant traumatic stress of continual legal proceedings. These years have served as a persistent open wound, preventing closure and forcing me to relive the worst moment of my life over and over again. My life is not just marked by her absence, it has been defined by a 20-year cycle of legal exhaustion and secondary suffering. The defendant didn't just take a life, they took my mother, my children's grandmother, and 20 years of peace that I can never get back. I ask this court to recognize the permanence of this loss and the exhaustion of a lifetime spent seeking justice.
Thank you, ma'am.
Thank you. Ladies and gentlemen, we will take a recess at this time for 15 minutes. Do not discuss the case among yourselves. Don't discuss it with anyone else. Do not do any independent research while you're away from us. Leave your pads and pens on the chairs. They will be there when you return, and I'll see you back in 15 minutes. All right, I'll see you back in 15 minutes.
I just saw that, yes, they will all have the same jury. They will all have the same jury. So I'm thinking that it's going to be like low-key reminiscent of the Sunny Bell trial, where all of those defendants were in there. And it looks, I think it's pretty much all of those defense attorneys as well from the Sunny Bell trial. So I think it's going to kind of look like the Sunny Bell trial with the evidence from Alicia Andrews. But the evidence may hit a little harder in this particular one. It may hit a little harder. I don't think he acted alone. I think people are more inclined to believe it's possible that he acted alone because he has taken a life before, twice, in different decades. So it looks more serial-ish than it does wrong place, wrong time-ish. But the fact that he was on the run from one unaliving after already serving time for another unaliving and somebody else ends up unalived, people may be more inclined to believe that he's capable of doing it rather than really looking at it as if this is his first time. Because at this point, he's already gone for 110 years. Ain't nothing happening with that. He got his head shaved, but if you seen him when he came in, the condition of his head, as gray as it was, like that, it was over. Like, he's not going to make it. He might make it, I don't know about him making it 11 years versus 110. But what they should have done, I think, is offered him a good old LWOP or another life sentence to go on top of the one he has to tell what actually happened to Theresa Ann Green. Because at this point, they still, like her son, her mother, everybody who is now having to relive this like it was 24 hours ago and not 24 years ago, still don't have no answers. They still don't know what happened to her besides she's gone. I would want to know what happened to my mama. I would want to know what happened, everybody, because I feel like them neighbors knew what happened. And I do think it was something that was explainable. I do. Because more stronger than him being an unaliver from a whole other side of the states is more stronger when you mess with somebody whose apartment and employment is hinged on all of this. I believe she was drunk out of her mind. I do. I believe she was drunk. But again, I don't always believe in those numbers. I understand there's a legal limit, but I also think that everybody's tolerance is different. And somebody who drinks every day or drinks on a more frequent basis can probably throw back 3 shots and not feel it. And whereas I wouldn't be able to put one foot in front of the other because I don't drink like that anymore. You know what I mean? So not necessarily going by the numbers, but I do believe that she had a bit to drink. And we know no matter how much you can tolerate it, no matter what your tolerance level is, alcohol thins out your blood, right? So if she slipped and fell, hit her head, went unconscious, the alcohol plays its part, and she's gone. Hell, somebody could have fell on her neck, or her neck could have got crushed, them falling down the steps, and that big ass man falling on top of her. You know what I mean? Like, or her body weight crunching up on top of her because she's falling head first. Like, it could have been anything as simple as that. And then butlers did not want to lose their job or their residence or have any issues or have to try to explain it. And it looked bad. And sometimes stuff looks so bad that the truth sounds like a lie. So I just think that in a way, They all covered it up. But in covering it up, here he is exactly 2 months to the date. Another woman is unalived and he's in the vicinity using a fake name. I think stealing Pete, aka Henry Field's van and torching it was trying to get away from what he did in Oakland. Because I still don't see him in that car or with her last or any of that without those butlers putting him there. And even if he was the last one seen with her, their apartment shared a wall in that tiny ass space. They heard it. They heard it. So I feel like the butlers have more to lose than anybody. And Lisa wasn't going to let her mama go down about her daddy shit. And whatever happened between her daddy and Theresa is the reason why all of this happened, drunk or not. That's it. And he just got the slap. He was all up in that thing because he was obviously messing with her. All of them are guilty. I don't think it's just him. I just don't think he deserves the death penalty for something that he didn't do alone. I think they should have LWOP'd him. He already got the 110 years. And then they should have got them butlers.
about how many more witnesses do
We are not, Your Honor.
you have witnesses that you intend to call via WebEx?
Yes, Your Honor, but at 1:30, California, it's 7:30 in the morning.
And there's no other evidence or anything that we could do?
Unfortunately, I mean, I would like to not do things out of order, so the videotape recording that we made in New Mexico of Mr. and Mrs. Alexander, obviously I can do that at any time, but we have their son, Sherman, to come right after that to sort of help explain it.
Okay.
But in any case, it won't be the whole morning.
All right. Then I'll bring the jury in. I will let them go to lunch and have them report back at 1:25.
That'd be great. Yes, ma'am.
Then we will try to get them on and make sure everything's working before we bring the jury back in at 1:30.
Yes, ma'am.
And do you mind if I explain that the witnesses that will be appearing remotely are in California, which is 3 hours difference, which is why we're waiting until 1:30?
No, ma'am, I don't mind at all. I mean, while we're here, I would like to move the court to strike the heinous, atrocious, and cruel aggravator. So the basis of our motion on that is based entirely on Dr. Utz's testimony, wherein he repeatedly said during his testimony that essentially he did not know if the victim was conscious, and that there were no defensive wounds whatsoever, which showed that she was struggling in any way. He continually qualified his answers about how long it would take for someone to asphyxiate. He said, if she was conscious, but there's no evidence whatsoever that she was conscious. And so that in and of itself would demonstrate that she couldn't have suffered if she was unconscious. And as I said, there were no defensive wounds whatsoever, which indicate that she was conscious. That the heinous, atrocious, and cruel aggravator has been described by the Supreme Court as proper only in tortious murders, those that evince extreme and outrageous depravity, as exemplified either by the desire to inflict a high degree of pain or utter indifference to, or even enjoyment in, the suffering of another. And that's in Rimmer versus State, 825 Southern 2nd, 304, Florida, 2002. I mean, since there's no eyewitness testimony from anyone who witnessed the strangulation and no objective evidence that demonstrates that she was conscious at the time, then I think it is impossible for the jury to infer from that either the amount of time that would have taken for it to happen, or if she could have been consciously aware that it was happening. I mean, the scientific evidence was that she was heavily intoxicated. At a minimum, something in the vicinity of 0.25. So there's just no evidence to support the case atrocious and cruel aggravator.
Thank you, Mr. Buxton.
Your Honor, we know from the evidence that there was no medical injury that would cause her to fall into unconsciousness. There's no brain bleed, there is no skull fracture, which we all know would potentially cause her to drift into unconsciousness. We also know that after they fell down the stairs, by the testimony of 3 witnesses, that she got up, walked up a flight of stairs on her own. She didn't have to be carried, she didn't have to be drugged up. So she was capable and aware enough to take step by step and go inside the house. We also know inside the house that there was a large hole in the wall consistent with a struggle, which was consistent with consciousness. We also know that her watch was broken, consistent with the struggle, and consistent with consciousness. Blood alcohol level, according to the autopsy result, was 0.28. We know it was likely a little lower than that. How much, we don't know, because of the alcohol and fermentation process caused by the decomposition process and bacteria causing alcohol to be produced. But regardless of the blood alcohol level, again, she was still conscious and aware enough to be able to walk on her own up a flight of stairs prior to her murder. Additionally, because we have physical objective evidence of the markings on her neck, on the back, on both sides of her neck, predominantly on the right side. And we know that the testimony is consistent with, and the jury could reasonably find, that those were caused by fingernail marks during the strangulation process. If they were from the defendant's hands, we don't have a linear set of 5 finger marks consistent with holding and not adjusting. We have multiple locations in multiple places. So if they're from the defendant, that means that he was adjusting multiple times and causing multiple imprints in different locations, which would be indicative of a struggle in the victim fighting. If those fingernail marks are from the victim, that is clearly signs that she was trying to remove his hands from her neck, that she was aware, that she was struggling, and that she was conscious. That struggling process, as Dr. Butts described, is going to delay the period of time by which it would take her to fall into unconsciousness, because as she struggles, the carotid artery and the jugular veins are going to get loosened up, blood is going to flow back into the brain, which is going to delay the unconsciousness from occurring. So bottom line, based on all of that evidence, a reasonable jury could find that that strangulation in and of itself, based on all these factors, she was conscious, she was aware of what was happening, and this was a suspicious forward.
Thank you. Any response?
Just only that I think the state's really pyramiding inferences at this point. I mean, Dr. Utz never definitively said that those were fingernail scratches. And certainly the scratches could have been caused by anything else. And he answered under cross-examination that, yeah, it could be anything. Anything could cause that. They don't look like fingernail scratches. And in any case, her fingernails were examined, they were removed, they were checked, and nothing was found. So I just think that also that we don't know when the death happened. It could have been hours after the fall down the stair. There's simply no way of knowing how long that could have taken. So it's impossible to link together all of these events in such a way that it amounts to her being conscious at the moment that this happened.
I'm going to deny the motion at this time. So I'll bring the jury in. I will excuse them for lunch, and then I need to have some additional discussions with the attorneys. So let's bring the jury in.
You want us to rest?
Yes, I'm going to have you rest in front of the jury.
Jury's entered.
You may be seated. Dave, you may call your next witness.
This time, Your Honor, the state rests.
All right, ladies and gentlemen, the state has rested its penalty phase case. I've spoken with the attorneys about the next witnesses that will be called. They are being called via video from California, which is 3 hours different from our time. And they anticipate calling them at 1:30. So I'm going to give you an extra long lunch break. I do apologize for that. However, I want to make sure once we have the California folks that all the equipment's working and you will be able to hear what's going on. So I'm going to ask that you be back at the location designated by the court deputies at 1:25. We will start promptly at 1:30 with those witnesses from California. Do not discuss the case among yourselves. Don't discuss it with anyone else. Do not do any independent research while you're away from us. And do not read or watch or listen to any news accounts of this case. Leave your pads and pens on the chairs. They will be there when you return, and I will see you back at 1:30. You may be seated. I am going to need, pretty shortly from the defense, its list of mitigators that you want me to include in the final jury instructions in Word.
Yes, ma'am. Is it all right if I provide it overnight?
Yes, that'll be fine.
Morning, Yates.
If you could provide those overnight in Word, and I'll just send them both to the 99 Orange email as well as to
Of course.
the prosecutor's team. All right, anything else that we need to take up? I'm gonna ask that you be back at 1:15. We'll try to get I'll have AV here at 1:15.
Okay.
And we will make sure that we have everybody, are they all in the same location?
No, they're all in separate locations.
Okay, so we're gonna have 3 separate links.
Yes, ma'am.
Okay. Well, if it works for one, hopefully it's working for everybody.
Hopefully, we had them all on Zoom yesterday. It was
We were
fine.
communicating with them yesterday, Your Honor, so we coordinated some lighting issues and some sound issues, but we think we've got that.
Okay, good enough, then I'll see you back at 1:15.
All right, guys. So it's only 11 there. So we'll be back at 1:15. I guess I can knock out these last 2 meetings, but we'll be back at 1:15 Eastern Standard Time to they didn't come through with a verdict on or a anything on Diddy's hearing. If you didn't see it, Diddy was arguing last week, appealing his conviction. He said throw the whole verdict away because the Mann Act is for commercial use, and this was all personal for him. Commercial use usually ends up with a profit, and he lost money, so therefore throw that verdict out. And since he was not guilty on all the other charges, just let him go and go head home. I personally feel like he might be trying to get out between this conviction, that 50 Cent documentary, and Keefe D's trial coming up in August. I think he's trying to get the hell out just in case he got to fight about Tupac. He can do it from the outside. Again, the 4 remaining defendants for the unaliving of Charles Jones or Julio Fulio, their jury selection officially started this morning. So that is for Sean Gathright, Isaiah Chance, Rashad Murphy, and Davion Murphy. And again, that Florida trial is for Final Destination. So we are going to be, that jury selection is supposed to take a little bit of a longer time, but it will also be, they expect to start testimony around April 22nd or 23rd. Then on the 16th, if this does not get moved again, in Columbus, Ohio, the Franklin County courts will be picking a jury in the case of Justice for Casey Goodson Jr. We know this is a second trial. We did rewatch the first trial together, but this time, disgraced murderer Meade is attempting to make his defense self-defense. So they're saying that even though Casey's back was turned and he took all these shots to the back as he was walking into his own home with AirPods in his ear, YouTube music playing, confirmed to have been playing, and a hoodie on, keys in his hand, Subway sandwiches in his hand, and opening the door, he was a threat to Meade, and Meade had to defend himself with a weapon on fully auto. So if they don't pull another doozy on us, jury selection for that trial should be starting on Thursday the 16th. Then in the meantime, in between time, we also have Something else happened this week. This happens this week, and I can't even think of what it is. I can't think of what it is. I will definitely look it up. I think by the 10th, didn't somebody had to respond for Alicia Andrews' motion to throw her stuff out too? Yeah, we need to check into that. Then we have some other stuff that may be on the horizon when it comes to YSL. It's crazy right now, guys. All right, well, I'm going to go ahead and knock out some analyzing. We'll be back at 1:30 p.m. Eastern Standard Time for the next part of the penalty phase for Mr. Demorris Hunter and the unaliving of Theresa Ann Green. I'll see y'all in a few.